10881, Hamilton versus City of Wilmer. Mr. Roberson.
Yes, sir. For the appellant, Mark Hamilton.
Please approach. Great. Whenever you're ready.
Thank you. May it please the court. Your Honors, I am privileged today to represent former Fire Chief Mark Hamilton, who happens to be here with his wife today. He has given his life in order to protect and serve his fellow citizens, and yet his ability to do so was taken away to him in a way that seems to me and to the First Amendment to be unlawful. This case turns on whether an employee can wear two hats at once, because Lane versus Franks in the United States Supreme Court stated that one can do so. The district court erred by focusing on the undisputed facts that one of those hats that Mr. Hamilton was wearing at the time was as fire chief. Now, taking a look at Lane versus Franks, it's very clear that truthful testimony...
I'm sorry, I'm interrupt you. I'm not sure the clock's running. You can, for some reason, it doesn't... There it is. There you go.
Thank you, Your Honor. In Lane v. Franks, the Supreme Court clearly states that truthful testimony under oath by a public employee outside the scope of his ordinary duties is speech as a citizen for First Amendment purposes. That is so even when the testimony relates to his public employment or concerns information learned during that employment. More importantly, in regards to the two hats here, the court states, first, it is a quintessential example of speech as a citizen for a simple reason. Anyone who testifies in court bears an obligation to the court and to society at large to tell the truth.
But is the test, is it fairly described as we look at the content and we look at the context to try to decide if the speech stems from ordinary official duties? Is that a fair way to put it? And if you put it in that context, well, the context itself is he's in his uniform, he's in the city car, it's during his work hours, and it relates to an incident in the fire department and a fire department employee. That just looks like a lot of official activity.
On one sense, it might, Your Honor. We would say under Lane v. Franks and also under Howell versus Town of Ball that it is not. In Lane versus Franks, the court went on to say, when the person testifying is a public official, he may bear separate obligations to his employer. And it's interesting, the example deals with what he's wearing. For example, an obligation not to show up to court dressed in an unprofessional manner. But any such obligation as an employee are distinct and independent from the obligation as a citizen to speak the truth. In further analyzing the Lane versus Franks definition of what is ordinary duties of an employee in Howell versus Town of Ball, the court was faced with an interesting case where a police officer was assisting the FBI in investigating his own law enforcement agency. Now, what the Town of Ball tried to say was, wait a minute, the definition of a police officer, according to Louisiana law, necessarily includes assisting other law enforcement agencies. If it's part of your statutory duty to do so, it must be the ordinary police officer's duty to so assist the FBI in doing this investigation of his own agency. The Fifth Circuit said, no, that is not the test we are going to use. It said, by such general implicit assumptions are not dispositive regarding the scope of a public employee's ordinary duty, because such broad assumptions fail to describe with sufficient detail the day-to-day duties of a public employee's job. Accordingly, we decline to infer solely from a Louisiana law enforcement officer's non-specific duty to detect and prevent crime that Howell, as a local police officer, it goes on, ordinarily had the job to assist the FBI.
He wasn't acting as a whistleblower here, right? That's not, that whole line of authority under Lane isn't implicated.
That aspect of it isn't, Your Honor, but the fact is, in his entire career, 9 years as a chief and 17 years as a firefighter, this was the first time he had ever testified under oath. More importantly, the questions they asked him were outside of the course and scope of his job duties, and Defendant Stringfellow was more than aware of that because she was the one who had told him he didn't have the authority to hire and fire people. She had taken that away from him. She knew, and the reason we know is because I attached the questionnaire that they asked him as to what did you testify to, that was attached as to the complaint. He clearly included a description of all the questions and all the answers that were given to him to the best of his memory, which at the time was only a few days old. She knew that they asked him questions about what would he do. Did he feel comfortable with him keeping that job? Even though it wasn't within his authority to fire him at all. So one, he had never done it before, so far from being a day-to-day task, as Howell versus Town versus Ball asks the court to look at, it was also not even within his job authority. More than that, and it's very interesting.
Is it relevant that it weren't his allegations? He did acknowledge he gets subpoenas all the time.
Well, that's totally different, Your Honor. That would make every custodian of authority, a custodian of records, totally incapable of ever having First Amendment protection for areas outside of which they're custodian of records. He was the custodian of records for firefighting items within the court.
So the city that fires him, what would you point to as the closest clearly established law that they should have known that his going during work time to testify was protected speech?
I would look at Lane versus Franks myself. I mean, now the difference was with Lane and Franks is the individuals involved admitted that this was not part of her, Lane's ordinary work duties.
What about you know, of course, I mean, the briefs have gone into it. We have cases like Rogers that would arguably make it more difficult to say that we have such a clear and understandable line as to what's official versus what's personal.
Well, in Rogers, and certainly that's the case that defendant Appley relies upon, Rogers, his entire job was as an investigator, and his entire job was then related to testifying as to his investigation. The reason in Rogers that the court said it was a close call, and as a matter of fact, the court said it might fall on the other side, and there was a strong dissent. But they said it was a close call because it was his job to investigate and to testify. Here, the investigation and the testimony was outside of his job descriptions. But it had never been Mr. Hamilton, Chief Hamilton's job to testify under oath. And the fact that, I mean, he was called not actually even as a fire chief, he was called as the person's supervisor. So does that mean every supervisor who's ever called by a district attorney, which is who had the subpoena in this case, loses their First Amendment right to tell the truth under oath, even if their boss is upset with the truth? I mean, if it's not part of your ordinary job duty to testify, whether you're a cop, whether you're a nurse, whether you're a fire chief, whether you're a ditch digger, say it's your job to dig ditches. Say there's a lawsuit related to the ditch that was dug. That individual, it's not their job to testify on a daily basis to subject a worker at Public Works to the Hobson's choice of being terminated if I don't make my boss happy or going to jail if I lie in front of the court. That's a Hobson's choice that current law doesn't allow the city of Wilmer to do.
You say in your pleadings that it was custom, custom's the word, for fire chiefs to wear their uniform in court proceedings, right?
Yes, and Your Honor.
And why can we not infer that it's custom for fire chiefs to wear their uniforms in court proceedings? Why can't we infer from that fire chiefs sometimes testify as part of their job duties?
Well, sometimes isn't ordinarily, Your Honor, and that's the question. I also said fire chiefs and firefighters. So if you're a police officer, whether or not you're an investigator whose job is ordinarily to testify, if you're an EMT, your job isn't ordinarily to testify, but you get called in a civil lawsuit to determine whether or not the leg was broken at the time of the crash or thereafter. It's not your ordinary job to do so testify, but that EMT shows up in their EMT uniform. as a former military officer, if you had subpoenaed me as Lieutenant Roberson and not Mr. Roberson, I would have shown up in my uniform, whether or not it was my ordinary job to testify, which it wasn't.
Can you tell me how Chief Hamilton's testimony was, quote, indisputably outside his job duties? That is the word, that's the adverb used in Rogers, that a public employee's testimony must be indisputably outside the employee's job duties. How can you overcome that?
Well, because the testimony is provided, Your Honor, and the testimony is about whether or not he, as the individual supervisor, feels comfortable with him doing certain things, implying that as a supervisor, he had the duty to fire this individual, and he didn't. And Ms. Stringfellow knew that he didn't. More than that, it's very interesting, Your Honor. First of all, that takes away the fact that the Supreme Court said you can wear two hats at once. The reason that language is in the petition, Your Honor, is because in their letter in which they terminated my client, that letter says, quote, "It is further alleged that you did so for personal reasons but appeared in uniform and arrived and left the courthouse in a city vehicle. Further, you did not request nor were you given personal time off for the action. These claims have been found to be true." So they fire him claiming you shouldn't have worn your uniform, you were on personal time, you should have taken leave. They also said, though, quote, "Your actions have painted a negative light on the integrity of the fire department and public safety in general, as well as besmirching the city's name." And I'm reading from his termination letter, which is a court record.
Is there anything in that letter that suggests the city fired him for anything he said?
Yes, Your Honor.
What's that part?
You painted, whether your actions painted the city in a negative light.
But the actions that you ticked off before that were about not anything he said, but what he wore and how he got there. And
Your Honor, you are correct, and I apologize. I read the letter out of order. The second half of the paragraph, which is what I read first, stated, "It was further alleged."
But why wouldn't that be an independent, non-speech related basis? In other words, if we move to the second portion of Garcetti, they're saying we as a city need to know where our employees are, especially a fire chief. If there's an arson, we need to know where they are, but you didn't notify us in advance, and then you didn't notify us immediately afterwards. Why isn't that unrelated to speech?
Your Honor, I believe that that is something that a jury could consider. Did they, as they say in the first half of paragraph 1, fire him because they didn't like his speech, because it painted the city in a negative light? Or did, as in the second half of paragraph 1, they fire him because they thought he should have been off the clock, despite the fact that...
But you agree that second half has nothing to do with the speech. So to the extent they're saying further, they have multiple grounds to terminate.
Yes, Your Honor.
Several of which wouldn't implicate any First Amendment protected speech.
Well, that's right, and I haven't moved for summary judgment. I haven't said there's no fact issue for the jury to decide. I've just said there's a fact issue here, and that fact issue is that based on the evidence that I attached in the complaint and based on Lane versus Franks, one, I believe the speech was the real reason, it was the motivating reason, and because it was the motivating reason, I get to go to the jury, and whether it ends up being but for or motivating cause later, when we get to that point, which is not where we are today, whatever standard is used, if they want to say the real reason was something that didn't have to do with speech, let them prove it. I'm not saying they can't. I'm just saying let me prove, let Chief Hamilton prove that the real reason was speech. And they, in the letter, say you were on your own time. Now they come into this court and they say no, he was on the clock. I'm saying he's allowed to be both. And the reason I'm saying that is because Lane versus Frank said it. It's quintessential. It's quintessential speech. It's under oath.
Right, but Lane is the originating decision. Can you point to any circuit decision that has said a city violates clearly established law when what they're punishing is on the time, in uniform, testimony about a person who is the subordinate employee? Right, that sounds extremely official. Even if it's not, where is there a clearly established circuit case in any circuit that says, well, the ordinary official duties doesn't extend to someone's subordinate doing something wrong inside the office.
Your Honor, I believe the Lane versus Franks.
I know, but I'm asking you for an application where a circuit said, no, it's clearly established, even though you're testifying about your own employee and what he did inside the workplace, that's still a citizen talking about something public. How would this city have been on notice?
All right, for example, Your Honor, I cite to Rayburn versus Bossier Parish School Board.
Which case?
Rayburn versus
Rayburn,
Bossier
okay.
Parish, 881 F. 3rd 409. And in Rayburn versus Bossier Parish, we had a school nurse.
School nurse.
And the school nurse, she took records. Those records were of what she did as a school nurse. Those records were then subpoenaed, and those records were entered into evidence. Now, the question was whether or not those items, her work notes, were protected speech or not. And this court said, the district court observed that Rayburn's job responsibilities were maintaining complete records on school activities, including the assessment. Rayburn stresses the Supreme Court's caution about over-reliance on written job descriptions, but she fails to create a genuine issue of fact as to whether or not the speech was made pursuant to her official duties as a school nurse. In the court cites to Lane versus Franks and says, quote, the question is truthful testimony under oath by a public employee outside the scope of their ordinary job duties. That's the test. That's all I want, this test to apply. She knows, Ms. Stringfellow, the defendant, knows, she read the questions. She knows those questions are outside of his job duties because she's told him his job duties. Accordingly, she knows versus Lane versus Franks and Howell versus Town of Ball, is the case where the court said, no, you just can't look to a job description, you look to what they did day to day. And really, Howell versus Town of Ball is my best case, Your Honor, and my time is up, so I will wait for rebuttal, Your Honors.
Thank you very much. Mr. Davis?
May it please the court. Bob Davis here on behalf of the appellees, the City of Wilmer and the City Administrator, Rona Stringfield. I think what we have here is a perfect example of a Garcetti situation where the plaintiff, the appellant, was doing exactly what his job description requires. It's what state law requires. Everything he did was testify in response to a subpoena as the fire chief about city personnel matters in a criminal case. He was not brought there as a character witness, unlike other cases. He was not brought there to talk about his personal beliefs. Everything that you look at this case, and in fact, since this court will review it de novo, look at the factual allegations in the pleading. There's two parts of the record that I think are dispositive. The record on page 15, and that is where it's alleged by the plaintiff, it is because in Texas, when a chief of a fire department is subpoenaed as chief by the state of Texas's subpoena, then it means he is understood to be testifying as chief of the fire department and not as a civilian. That's exactly what we have. The second thing is at the record at 138. This is from...
What if the state of Texas, subpoenas him in either a criminal case or a child custody case, and it has nothing to do with the fire department or employee, but it is during work time? You'd say...
I think factually that could be just different or distinguished, but here we don't have that parameters. We know, based on the well-pled facts, the plaintiff essentially pled himself out of court. He also, at the record at 138, in response to one of his questions, and he's attached this to his pleadings, I did go to court when summoned by the Dallas County District Attorney's Office in a response to a subpoena from the prosecution addressed to Chief Mark Hamilton. This was not for personal reasons, as Ms. Stringfellow has stated.
But if he'd seen embezzlement by the city administrator, then that's directly analogous to Lane, correct? If he'd gotten a subpoena to testify about city embezzlements, that would be protected speech.
If he was testifying as the chief in his official capacity about information that he
Right, but
learned-
that's our question. He was chief and he saw the embezzlement, or frankly, even Lawrence himself. Let's say he'd seen Lawrence doing what Lawrence is alleged to have done, but he had also warned internally the city administrator, look what Lawrence is doing, and they'd done nothing. Then wouldn't that also be protected speech?
You have a Lane situation, but then you look at the dichotomy with Garcetti. How does that reconcile with Garcetti when they say, and Garcetti tells us, the threshold inquiry in any Section 1983 First Amendment is whether the plaintiff was speaking as a citizen or whether he's speaking in furtherance of the duties of his or her public employment. And as this court has said fairly recently, I cited a trilogy of cases. I like Dusterhoff.
Well, what was Lawrence? This was a criminal revocation, correct? He gets revoked and
In this factual situation, I think what I'm gleaning from the plea, it was some type of plea hearing.
yeah, he was admitting to facts that revoked his sentence, and then he goes right to jail.
And he went to jail that day by the trial court, and yeah.
So anyone that's a fact witness about whatever was or wasn't in that bathroom would get a subpoena. They'd have to show up, citizens, and testify to what they knew. How does this implicate his official role as a fire chief? It's not about an arson investigation.
It's about what they asked him to testify about and what he did testify about. He was asked about Mr. Lawrence's employment with the city, whether he had been disciplined before, whether they expected him, whether they felt comfortable with this firefighter going into the public's houses. Those are not matters that a citizen would know or even be competent or qualified to testify about. This is something within the unique sphere of the chief of the fire department as the supervisor of this individual who's in criminal court. This is not something that, in fact, a citizen wouldn't have access to that information.
You want to speak to the two cases he emphasized at the end, Rayburn versus Bossier, and then Powell versus Town Hall?
I apologize, I'm not familiar with the Bossier City case. I think,
Well, if it's not in his brief, you wouldn't be. But he said his strongest case was the Town Hall.
and I would, in our brief, I think, to answer your question, Judge Higginson, the best cases or the strongest cases for the city would, of course, be Garcetti, the Dusterhoff versus City of Austin, which I've cited in the brief, the Foster versus Blease. We got Rogers versus Hall. This court, in the past several years, has addressed this exact scenario.
How would you describe the rule of law articulated in Rogers?
Well, in Rogers, this court said that it's the same thing, that if the employee is testifying or speaking on behalf of his official capacity or official business, he's not doing that as a private citizen. And it goes to the factors which this court has articulated before, his job description, the things that he customarily does. And I cited in our brief some state law cases. It is...
You studied Rogers fairly well? In other words, are you going to be able...
I've read it to the point that I'm conversant.
You're familiar with the dissent?
Yes, Judge Costas.
Judge Costas' dissent cites an earlier in time decision called Bevel. Do you know Bevel?
And I think...
Do you know the decision, the Bevel decision, or not?
No, Your Honor, I don't. But I do know Judge Costas' footnote. We're on page... his footnote number 1 on page 308, where he says, and this really goes to immunity, but this is, I think, certainly dispositive of the administrator's immunity. He says, and this is 46 Fed 4308, page 314 at footnote 1. This is Judge Costas. Because we have not answered the question that Lane reserved, qualified immunity would provide a defense to any speech claim based on testimony that part of Rogers' job, that was part of the law cannot be clearly established when the law is unsettled. Mm-hmm. I mean, that is the essence of one of the prongs of qualified immunity.
You may have a compelling argument. When would you think we would settle the law so that cities would know?
I don't know when this court would. I think this is something the Supreme Court hasn't even answered. They dodged that. They did not answer that. And this court and other circuits have yet to come up with, from my research, any definitive answer as to, is there that point where counsel has said where they wear two hats and they can have protection under both hats? Today, no. Today, when they wear the hat, the fire chief hat, and that's a good analogy.
Is it relevant that factually he points out or alleges that and we take it in the light most favorable, that he's never testified. Is that relevant?
It's
to the
completely irrelevant. That's just happenstance. I mean, he testified. I get subpoenas all the time. Wilmer's a tiny little city. The fact that he's never actually gone to court and testified doesn't matter. The core issue that's relevant to that question is that something that's a core function or an official function of his job as the fire chief? Absolutely. Fire chiefs get subpoenaed. They do testify in lots of cases. It could be an arson case. It could be a person. But here's another thing. For example, what if he were subpoenaed, or what if he were called to testify in a civil service hearing or before the city council?
Well, I may have asked this before, and I don't mean to ask too many questions, but let's imagine the subpoena related to a civil case involving Lawrence and child custody.
Right.
And he's told he has to show up during the workday. Would you say that still would be an official duty testimony?
It would depend on what they brought him to testify about. If they brought him to testify, like in Rogers, where Mr. Bobo, the person that got into the fight at Parchman, that he was brought there to basically be a character witness. If the chief were called in a family violence case or in a divorce, hey, is Lawrence a good guy? That's probably not an official duty. That's a personal opinion. But under those same circumstances, under that same subpoena, if they say, has he ever been disciplined as a firefighter at the city of Wilmer? I think then you push it back into the sphere of official duty, official testimony, because the chief would know that.
Your letter of termination was multi-paragraphed.
It was.
Were there independent bases, and do any relate to non-speech? You didn't bring that up until page 33 of your brief.
Well,
But is that separate from the underlying difficult speech relationship to the job?
The focus, at least at the motion to dismiss stage, was just the fact that he was not speaking, well, that he was not acting as a private citizen. The letter it's got multiple grounds, but as your honors pointed out or questioned, there is a compelling public policy for the city to know where their police chief is and to advise his superiors, his city administrator, where he is and what he's doing. Think about this in the context of this. Mr. Lawrence was arrested for invasive recording, putting a camera under a bathroom stall. Mr. Hamilton didn't tell the city that his subordinate, his employee, had been put in jail until at least 24 hours. Can you imagine the media spectacle that could have happened? Nowadays, and it's no surprise to anyone, public officials, police officers, law enforcement, firefighters, that hits the internet in seconds. The city needs to be advised so they can respond accordingly in a timely manner. Can you imagine what would have happened if the city didn't know that one of their firefighters had been convicted and was in jail for that, and they were caught off guard? That's the public policy reason. That's one of the reasons why the city has these type of processes.
My recollection is the record was very open to dispute about when he's trying to tell various people and who's where, and people are busy. But you may be right if you're saying starkly that was the chronology.
Right. I was not involved in the underlying disciplinary actions. I was hired at litigation. I've read the termination letter, but as your honors have pointed out, there's nothing that said, we're firing you because you testified in the criminal proceedings. He brought disrepute to the city, as the letter said. He brought disrepute. He didn't advise his supervisors that one of his subordinates had been convicted. There's nothing in the letter, on the face of the letter, that says we are punishing you, or that their conduct, or the city's conduct, was motivated by his speech. And that's important. And I don't bring that up because I think the other issues are equally, if not more, the law is better for the city on that he's not speaking as a citizen, but it is important. The trial court did not focus on that as much either, so I didn't in my briefing, but it is certainly something for this court to consider, that the basis for his termination was not the content of his speech. There were multiple grounds articulated in the reason for terminating him, which don't support a First Amendment retaliation claim.
And you're confident that the record bears out that what he didn't notify him of was Lawrence was convicted in front of him? When you say convicted, you mean there was a determination of guilt, or you don't really know what that hearing was about?
I don't know, the records,
So it may not have been a conviction that he would have notified, it might have been something else.
the termination letter talks about the fact that he did not notify the city of the arrest. They use the word arrest, and I believe, and again, that may be an inartful use of the word arrest by whoever wrote the letter.
Taken into custody.
Taking into context, I think they mean, from what I read from the pleadings, is that he was put into custody after that revocation hearing, whether it was I presume, but don't know if the record is clear, that it was some type of plea agreement. I don't think the record speaks one way or the other. But there was some type of dispositive hearing in a criminal case for which the chief of the fire department was subpoenaed by the prosecution to testify on issues that are solely within the sphere of his official duties and solely which related to city business. There wasn't anything that I found in the record that Mr. Hamilton was asked, what are your personal beliefs about Mr. Lawrence? How do you feel about him? They asked him about his job. They asked him about his discipline.
Okay.
I think that falls. I'll address the qualified immunity very briefly because that was one of the many bases that I asserted for dismissal on Ms. Stringfield. But I think Judge Costa's dissent in Rogers encapsulates that. I mean, how in the world, Wilmer's a tiny little city in Dallas County. How in the world would a city administrator be able to answer what the Supreme Court hasn't? And this court hasn't. I mean,
well, speaking of legal questions, what was the city attorney's basis for saying that he or she would have instructed the chief not to testify if been made aware of the subpoena?
I wish the record was clearer on that. I don't know.
Well, what basis would the city attorney have to instruct?
Well, hopefully he would not tell him not to testify, but there would have been some guidance as, Mr. Hamilton, if you testify in any legal proceeding, make sure that it's very clear you are not speaking on behalf of the city, which only acts through its city council, but you are acting as the chief. If you want to talk about the chief's policies or the chief's instruction. The other thing, too, is that...
I'm sorry, I don't mean to interrupt, but respectfully, that's not what the complaint says. The complaint doesn't say, I would have instructed the chief to make clear which hat you're wearing or whatever. The complaint says, I would have instructed the chief not to testify. To disobey the subpoena is the exact phrase.
I hope that was not articulated, or that was not the message sent by the city attorney. I don't know that that is in the record or one way. I know that's one of the insinuations, but that would be improper. And if the city attorney said, if you receive a subpoena, don't testify, that's not right.
That would be illegal.
That would be improper.
So what I mean, it's in the complaint. It looks like a well-pleaded fact.
It's an interesting fact, but I don't think it's material to this court's review or disposition of this case. In this case, what we have is the well-pleaded facts, which this court will review de novo, of course, but the trial court listed a litany of them.
Can I ask a question this way? Would it matter if the subpoena was addressed to Chief Hamilton as chief of the fire department? Would the city attorney have any ability to say, this is clearly directed to your official duties, things that are going on inside the fire department. I'm instructing you not to testify.
No, but the city attorney could.
Okay, I just want to do the other one. I'm sorry, I don't mean to interrupt. Just want to make sure I get both answers. So suppose it said, this is directed to Mr. Hamilton. Please wear a suit. Please don't. It has nothing to do with. This is about it's a divorce proceeding.
And that would have been.
Could the city attorney instruct him not to testify then?
No, but
so there's no set of circumstances where you could.
No, if he received a lawful subpoena, he's compelled to testify, and that's not what I don't see to be an important or dispositive issue in this case, because the reason that they want to meet with the city attorney, and a lot of cities that I represent have similar requirements, is to make sure, first of all, some of these folks are not very sophisticated. When you go to court, stand up, there's basic things to prepare a witness to testify when receiving a subpoena. They want to see if there's a ducus tecum. What if they're asking for records? There's a lot of procedural things that happen that I do as a city attorney when someone gets a subpoena. What if it's an improper subpoena? Then the city attorney may file a motion to quash or to modify or for protective order. There's a lot of mechanics that go in. So the fact that he didn't report it cut that off at the knees. It prevented the city from even seeing what he's doing, saying, etc. So I think as a city attorney, I understand why if a employee, especially a high-level fire chief, gets subpoenaed to appear in what potentially could be a very high-profile and negative media case. They knew that Mr. Lawrence had been in trouble. This had been going on since 2019. The criminal case kind of languished during COVID, and then it picked up again. They knew he had been charged with this offense, and basically he was just coasting, and they wanted to see how the criminal case played out. So you can understand the city's, I don't want to say nervousness, but their concern that they be advised as to the progress of this criminal case. And that's what didn't happen. And that's what I read, and I think this court can certainly infer from the disciplinary action. They're not concerned that he testified. They're concerned that there was this at least 20, and this is an undisputed allegation, there was at least a 24-hour gap before Mr. Hamilton even told the city administrator that Mr. Lawrence was in fact convicted and put in jail that morning. He kind of hedged a little bit. He emailed and said, oh, guess what? Mr. Lawrence resigned today. True, but that's not the important thing. Mr. Lawrence resigned because he was adjudicated of recording people under the bathroom stall. And it's in the pleadings, it's in the record, all of this, I was going to tell him later, I just didn't have a chance, I didn't do it. Those are important facts, and that goes more to the motive of the city, which I don't think we even really need to get into for purposes of this appeal. If you like, I can address the motion for leave to amend. I think the court certainly did not abuse its discretion in doing so. Mr. Hamilton gave it his best shot. The district court, as this court has advised, articulated the reasons why she did not believe that leave would be permissible, futility being the primary one. I think that's certainly an absolutely valid reason, and this court should not. I don't know what else he could have said differently that would have changed the facts. His own admissions, and again, the two that I pointed out in my initial comments, I think are very compelling and dispositive. I didn't do this for personal reasons. I did it testifying as the chief of the fire department, not as a civilian. That's Garcetti. So this is a case where, and the court asked him, well, what are the examples of where he was testifying as a citizen or on a personal basis? There's nothing in the record to suggest that at all. Everything in the record consistently is that he did this official capacity, testified about things that only he would know as the chief, not as a character witness, unlike Rogers, where it was a character witness called on behalf of one of the involved employees at Parchman. We don't have that here. I think this falls in line with this court's precedent and falls in line with the rule of law of Garcetti. There's no allegation, in my opinion, that pulls us out of the sphere of unprotected speech for which the city could take disciplinary action.
Thank you, counsel. Mr. Roberson.
In regards to the content of the testimony and whether or not it was within his duty or not, the court can take a look in the record. The entire content is attached. Unfortunately, the ROA's knocked out by the app number, but it is attached as Exhibit C to the original complaint. It's around page 33 in the ROA.
Is the subpoena there too?
Yes, it is.
So, does the record reflect this was a criminal conviction or a revocation, sentencing? What was the hearing?
Although it's not in the record, Your Honor, you can take judicial notice of it. It was a revocation. He had previously pleaded deferred adjudication.
I see.
He had not told Chief Hamilton that. To the opposite, he had said, nothing is in the record. I haven't been found guilty yet. He pled no contest, took 2 years deferred adjudication.
Something happened.
What happened was they asked, when he came up to his, in some setting, I don't know where, they said, give me your phone, and there was porn on his phone, and one of the terms of his deferred adjudication was no immoral conduct.
So it was a revocation hearing which combined both admitting to the underlying fact and then he gets remanded to custody. Okay.
In the totality of Chief Hamilton's testimony is such: state your name, who your employer is. Does Mr. Lawrence work for you? Yes. Is it true you hired him after he was charged in this case? No, Mr. Lawrence has worked for the city since 2013. Are you aware of the allegations against him? Yes, I only know that he was what he told me because the DA's office and the Dallas PD refused to talk to me regarding the case. Would you be surprised if Mr. Lawrence has visited adult sexually oriented website on his phone? Yes, I would. Knowing his charges, are you concerned with him going inside of people's houses? No, I'm not. He has never faced disciplinary action in any place of employment that I'm aware of. That was all the state asked. And then the defense asked, how long have you known him? More than 20 years, longer than he had been at Wilmer. How did you, Mr. Lawrence, meet? We met while I was working at the Seagoville Fire Department, where he started as a volunteer. Does this sound like the Mr. Lawrence you've known for over 20 years? No, it does not.
So what compelled testimony would you say would be official, only relating to, say, arson investigations? What would be your orbit of ordinary official duties?
Under Lane v. Franks, as interpreted by this court in the nursing case that I told you about previously, Rayburn, and as interpreted by Howell, which says, look to their day-to-day activities. The nurse in Rayburn versus Bossier Parish, which is in both of my briefs, Your Honor, both my original brief and my reply brief, Rayburn is there, said this was part of her duties. This is what she did on a daily basis. These were her daily notes. Therefore, when these notes were pulled by subpoena, the speech that's in those notes are employer speech, not employee speech. Here, because Lane v. Franks says quintessentially when you're under oath, you can go to jail if you lie, because a courtroom is always open to the public. It is citizen speech. Now, quite frankly, Your Honors, I think this court should answer two questions that it hasn't answered before, and I also would like to talk for a moment about Monell liability, but specifically—
I'm not sure you quite answered what would be official speech for a fire department chief.
For example, on a daily basis, who's assigned to a truck and why? Why did we order that ladder instead of that ladder? What kind of inspections do we do in order to make sure our trucks are working properly? The things that a chief does on a day-to-day basis, never once, much less on a day-to-day basis, had he ever testified. If I may, just quite—
No, go ahead. I interrupted you. Go ahead.
In regards—
Make your points within a minute.
Yes, Your Honor. In regards to Monell liability, the web case that we've cited shows that even if the court were to say that Lane v. Franks wasn't clear enough that there is liability against the city, it's undisputed. And we even, not only is it in our response brief that this is what we can add, yes, the court said it's futility, but she was focusing on the you can only wear one hat. All right. We would have been able to clarify why he was wearing two hats. We would have been able to clarify in regards to qualified immunity why Ms. Stringfellow, but we would also have been able to clarify, she said our allegations were conclusory. Well, we would have been able to clarify why the city's actions qualified under the third prong of Monell. Now, finally, Rule 15 and Local Rule 15 have nothing to do with this case. This is a Rule 12 case. Local Rule 115 deals with Rule 15 motions. Under Rule 12 in this court's prior cases, you get at least one bite of the apple.
Okay, I think we have that. Thank you very much. The case is submitted. We appreciate counsel. We'll call the second case of the day, but no rush. 23-20494.